Good evening, everyone. I am C. Aman Rajput, moderator of this webinar. We are delighted to welcome you all in this webinar being organized by the Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI, which is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value by combining analytical foresight and commercial acumen. The core area of this committee is to serve multifunctional task of analysis, spreading knowledge, and providing inputs to regulation and policy formulation to develop and publish technical guidance and background materials extra. Also, this committee works on creating awareness for professional opportunities for chartered accountants in commercial law, economic advisory, and NPO cooperative. In today's webinar, our eminent speaker, CA Gyati ma'am, is going to talk about prospects for CAs under environmental laws. Hoping this will be useful for all our members. Now, let me introduce our speaker for the session, CA Gyati Gupta ma'am. She is a practicing chartered accountant from Meerut, working in a field of direct and indirect taxation. She is currently the chief editor of e-newsletter published by Meerut branch of CIRC of ICAI. She has been addressing recently qualified chartered accountants for interview preparation for last 2 years. She has also addressed newly qualified chartered accountants at CIRC level. She has authored more than 20 articles published on various online platforms, and also she had contributed in many of the branch journals. Currently, she has been acting as a guest lecturer at Chaudhry Charan Singh University, Meerut, where she takes up the lectures on the intellectual property rights, industrial laws, environmental laws, and laws related to the competition. We welcome you, ma'am.
Thank you, Aman, for introducing me. Let me share my screen. And at the same time, I'm thankful to the committee for having me as a speaker today on this very suitable topic, professional opportunities for CAs in environmental laws. Please confirm, Aman, am I audible?
Yes, ma'am, you're audible, and screen is also visible.
Okay, just hold. Okay, so far in our CA journey, we have discussed about corporate laws, like we have studied about Companies Act, we have studied about LLP, we have studied about Indian Insolvency and Bankruptcy Code. We have also studied about economic laws, which include guidance on FEMA, guidance on SEBI. We have also studied about business laws like Sale of Goods Act, Indian Contract Act, Limited Liability Partnership Act. But nothing so far has been discussed about environmental laws. And believe me, that environment is a global topic. Much has been talked about it at the global level. Countries are meeting annually, half yearly, quarterly. There are many discussions going on, but we chartered accountants have yet not ventured into this field. And we believe that if we know less, does not mean there is happening less, right? So it is a very good field to venture into for chartered accountants. And today is a very suitable day, being the World Environment Day. 5th June is celebrated as World Environment Day globally. And we are having a session on this environmental opportunities in environmental law on this very suitable day. And every year, a specific theme and a host country are chosen to highlight a particular environmental concern. For example, past themes have included beat plastic pollution, only one earth, ecosystem restoration. And the theme for current World Environment Day is beat plastic pollution. Just a piece of information to add that this is being hosted by Republic of Korea, with Jeju province serving as the focal point for global celebrations. And why we are celebrating this World Environment Day? To raise awareness among people about the environmental issues that are there, to promote action, to initiate action for the environment, to encourage global participation, and to encourage policy changes. Like many much discussion is happening at the global level, but that has to be implemented. So that is why we celebrate this World Environment Day. And reminding you of the basics, when we were in school, we have definitely studied about fundamental duties and fundamental rights. So let me remind you that Article 51A, which is added into the Constitution via 42nd Amendment, it is the part of fundamental duty. It says that it is the duty of every citizen to protect and safeguard forests, lakes, rivers, and wildlife. And a duty just does not limit only to the protection, but we have the duty which goes beyond protection. And so citizens should aim to enhance environmental quality. There should be compassion for living creatures. So that is what Constitution of India teaches us. Moving ahead, environmental laws are essential worldwide. They help protect natural ecosystems. They help in reducing pollution and ensuring sustainable development. You must definitely heard about net zero carbon target, which India is aiming to achieve by 2070. Right, so these laws are there to safeguard air, water, and soil quality, promote conservation of biodiversity, and play a critical role in addressing global challenges like climate change. So proceeding further, and let us look what we'll be covering in today's session. We'll see what are the environmental laws that are there in India, how these laws have emerged, what are the timeline of international events. We'll just have a look at this, the timeline of international events, and we'll focus more onto this part, onto this segment, that what are the opportunities for chartered accountant in the sector of environmental laws, right? Moving to the very basic question, what is meant by environment? Let me tell you that Albert Einstein has put it in very simplified and in a very witty way before the people. He says that everything that is not me is environment, right? Everything that is not me, with air surrounding me, water surrounding me, people surrounding me, they form the part of my environment. And this is what suggested by the definition which is given in the Environment Act 1986. It says environment includes water, air, land, and the interrelationship which exists among and between water, air, and land, and human beings and other living creatures, plants, microorganisms, and property. With this, we move ahead and we understand what are the different environmental laws that are there in India. There are more than 50 plus acts, laws, and regulations, but here I have mentioned just few handpicked laws, like the Environmental Protection Act 1986. It is one of the most prominent act in the environmental laws. Then Air Prevention Control of Pollution Act 1981. It talks about maintaining the air quality, collection of air samples, and all. Then we have Indian Forest Act 1927. Indian Forest Act 1927 is probably one of the oldest environmental laws. It talks about regulation of forest produce. Forest produce, like it was regulating forest produce like timber, rubber, and other commercial crops, and it was aimed at curbing various activities, illegal poaching, hunting, grazing. So it was focused, it was centered around those activities. Then we have Water Prevention Control of Pollution Act 1974. The National Green Tribunal Act 2010. It is one of the recent acts of under environmental laws. Then Forest Conservation Act 1980. It talks about mitigating, reducing deforestation and promoting afforestation. Then we have the Wildlife Protection Act 1972, which talks about protecting the endangered species, rare species. Then we have the Public Liability Insurance Act 1991 and Compensatory Forestation Fund Act 2016. Besides this, we have other acts as well, which are centered around biological diversity, energy conservation, hazardous waste management, etc. But we'll see, we'll have the view, we'll have some We'll discuss some important points from each act so that you will have the understanding of broad framework, how the environmental laws are working and what do they cover under their ambit, right? Now, I mentioned that environmental laws, one of the most prominent act is Environment Protection Act 1986. If you observe the year, it is 1986. This prominent act came into existence subsequent to Bhopal gas tragedy, a very serious tragedy that occurred in 1984, and I believe we all are aware of it. What happened during Bhopal gas tragedy? And there was a poisonous gas, methyl isocyanate. It escaped from a plant which was owned by a US based subsidiary, Union Carbide Corporation. And when investigations occurred, it was found out that this tragedy took place because of the usage of substandard operating and safety procedures due to understaffing. So you see, there was just a lag, means there was no standardization of safety procedures that time. And this tragedy took place. I happened to talk to a few people who were from Bhopal itself 2 months ago, and I asked them about whether people who are living in that area where this tragedy took place, they are still feeling the after effects of that tragedy. So they said yes, the after effects are still there, and even believe the remains of that tragedy, remains of that Bhopal gas power plant is still there. No one is courageous enough to take relocate that remain from that its original location. So we need to understand how grave the situation is if there are no environmental laws. Okay, so that is why Environmental Protection Act 1986 came into existence, that addressed the issue due to which this tragedy occurred. It talked about it laid down the standards for emissions. It also laid down the standards for operating and safety procedures that you should use, that should be there if you are setting up any industry or you're setting up any factory, right? Then we have another case that was also very famous, Shri Ram Food and Fertilizer case, Delhi. What happened during this case, that this Shri Ram Food and Fertilizer, this industry, this factory was set up in one of the busiest areas of Delhi, and there was a leakage of oleum gas. Thereafter, what happened when the gas was leaked? Of course, there was a lot of damage, there was a lot of deaths of people. So Supreme Court ordered that if any organization is operating operating in such a way that it is hazardous and inherently dangerous, it is carrying out inherently dangerous activity, which results into the escape of toxic gas, then that enterprise is definitely strictly and absolutely liable to compensate all those who are affected by the accident, and such a liability is not subject to any exception. This has been a very famous case. So these two cases are, means there are many other cases as well, but these two cases gained a lot of traction and it led to the emergence of new laws into our country. Then we also have one of the very serious case from Japan, is Minamata disease that occurred in Japan. What happened during, what happened in this case, that there was a chemical factory and it was discharging methyl mercury into the industrial water. That poisonous methyl mercury was being consumed by aquatic animals, it was being consumed by fishes and other aquatic animals, and those animals were being consumed by human beings who were living in those in the surrounding area. So that methyl mercury, which was an industrial waste, it was an untreated industrial waste, it indirectly transferred from industry to human beings, and it caused a huge deformity in the body parts of human beings. And even after 50 to 60 years, its after effects cannot be completely mitigated. Its after effects are still felt in Japan. So you understand how important the emergence of environmental laws is, right? So these were the three cases where government took action after serious damage was already caused. But there are some certain cases where government took proactive action. One such case was yellowing of the Taj Mahal. If you visit Agra, you will definitely observe that there are no coal or no coke industries in so what government did, it observed that Taj Mahal was turning yellow because of the coal, because of that smoke which was emitted by those coal industry. So it marked a area surrounding Taj Mahal, a particular area surrounding Taj Mahal, and named it as Taj Trapezium. It suggested, it ordered that no coal or coke industry shall be set up in the area which comes under Taj Trapezium. And all those industries were relocated outside Agra. So this was one of the proactive action government took. Then we had Dehradun Valley case. Again, here government proactively intervened. What was happening into it? In the Mussoorie Hill range, there were limestone quarrying was being carried out. There were continuous extraction. There were continuous blasting of mines to extract limestone from those mines. It was it could cause potential damage to the habitants living there. So that is why Supreme Court ordered the closing of limestone quarrying in the hills, and they observed that it would cause undoubtedly hardship to them, and it's a price that is to be paid for protecting and safeguarding the right of people to live in a healthy environment with minimal disturbance of ecological balance. Then just a piece of information. Few days ago, I was addressing a group of college students and I asked them that can you go and stop anyone who is smoking in public, who is smoking, who is, for example, you are traveling in a bus and if you see someone smoking in the public, they said, no, ma'am, why would we do so? Then I again asked them, do you have any authority to stop them? They said, no, ma'am, it would definitely lead to some fines. I insisted them that can you ask police to stop them? They said, no, ma'am, we don't think so that police have any authority to stop them. So let me share that smoking in public place is prohibited nationwide from 22nd October 2002 onwards. But since we are not responsible enough that we should follow such rules, we should follow such law, but we are not following it. So this is somewhere giving us everyone the impression that there is no law to stop such activity publicly. But there is actually a law. But the law loses its relevance if it is not implemented. It becomes important if it is implemented in the way it is intended by lawmakers, right? Just one additional piece of information I wanted to share with you. Moving ahead, here is the timeline of international events that occurred at the very important event, the very first international conference of all the countries that occurred in 1972. We must have heard about the term sustainable development. So the sustainable development, it came during 1972. This term was coined during 1972 Stockholm Conference. And 113 countries participated into it. And there were many agendas that were discussed. Then come 1992, of course, as I've already mentioned, that the countries are meeting annually, half-yearly, quarterly. There are many programs that are being taken place in this direction to reduce the carbon emission, to reduce the pollution, to address different sorts of pollution. But these are some of the landmark conferences that occurred globally. 1972, then 1992, we had Earth Summit, where Agenda 21 was adopted. Means 21 key areas were identified where it was felt that we need to intervene and to take some action, serious actions. Then in 1997, we had Earth Summit 2. Then 2002, there was a World Summit on Sustainable Development, and it occurred in Johannesburg. Then there are other treaties as well. that took place in 1971, 2001, Stockholm Convention, Vienna Convention, Montreal Protocol, Kyoto Protocol, COP24, COP21, Rotterdam Convention, Minamata Convention, COP25. So Minamata Convention, we already discussed, it is related to the Minamata disease that emerged in Japan, right? So far we have discussed that there are environmental laws, but we need to understand that which body is responsible for implementing, for supervising this environmental governance in India. So that is Ministry of Environment, Forest and Climate Change. So Ministry of Environment, Forest and Climate Change, it has enacted more than 450 rules, regulations, and notifications for the control of all sorts of pollution. It is tasked for the responsibility of formulating policies. It makes rules. It ensures international cooperation. It engages in research and development. Shri Bhupendra Yadav is Union Cabinet Minister and Shri Ashwini Kumar Chaubey is Minister of State. So the very first body is Ministry of Environment, Forest and Climate Change. If countries are meeting worldwide, so whatever treaties are being signed, whatever discussions happen, they are implemented into the country via ministry itself. And the ministry is Ministry of Environment, Forest and Climate Change. Then we have two other bodies, CPCBs and SPCBs, Central Pollution Control Board and State Pollution Control Board. So they also work under the supervision of this ministry itself, right? So this is the website of ministry. And here you can get the information related to all the latest rules and regulations about the ministry itself, their different organizational structure, the project approvals, and everything you can get from here, all sort of information. Then discussing the broad objectives of ministry, conservation, survey, flora and fauna, prevention and control of pollution, afforestation, protection of the environment, ensuring the welfare of animals, etc. Then we have, as we discussed, Pollution Control Board, the very first being Central Pollution Control Board, which works at the central level. And then every state has its own state pollution control board. So these pollution control board have been set up under Section 6 of the Water Pollution and Control of Pollution Act 1974. Let us look at the constitution of these PCBs. You might be wondering why we are discussing it, because before venturing into any field as a chartered accountant, you must understand the broad framework, how the things are working, who is regulating that sector. So that is why it is important to understand this flow. So we have PCBs. Let us understand their constitution. We have one full-time chairman. We have 5 representatives of central government. We have 5 representatives of the state board. Then we have 3 members to represent the interest of agriculture, fishery, industry, or trade. Then we have 2 representatives of corporates and companies. And then we have 1 full-time member secretary. So this is how PCB has been constituted. It has made sure that the participation from different sector should be there. So that is why there are so many people into the board itself. Then you can understand the organizational structure. As we have seen that there is 1 full-time chairman, 1 full-time member secretary, and other people in the board. And also we have 37 divisions. These are the divisions, and 9 regional directorates. 9 regional directorates at different places: Bengaluru, Bhopal, Kolkata, Lucknow, Shillong, Vadodara, Chandigarh, Chennai, Pune. And these divisions, like if we have IPC stand for Industrial Pollution Control, means the pollution which is emitted by industry, how to control it there. So there is a dedicated division to it by CPCB. Then AQM is Air Quality Management and Air Quality Management Network. And then WQM is Water Quality Management. WM is Waste Management. UPC is Urban Pollution Control. Then there are laboratories and other divisions, IT, R&D, planning, law, etc. What else CPCB do? CPCB, it provides technical services to the ministry. ministry which is formulating the law. So it is aided by CPCB because CPCB provides technical services to the ministry. Moreover, there is a data uh, which is regularly published by CPCB. That data is related to air quality monitoring, the air quality index, which we were definitely tracking upon during COVID times, if you remember. So air quality index, water quality index. So this is the data which is published by CPCB. If you go to their website, I have attached this screenshot taken in the morning itself. So this CPCB website you can find in under air, water, noise data tab, air quality data, and then they have daily AQI bulletin, and they published PDF on daily basis, and it might interest you to know that that PDF includes city-wise air quality index data. Then the other CPCB's role, it monitors pollution level, as we've already seen its website. It helps in research and development, it sets standards, and it helps in capacity building, right? Then we talk about SPCB. So one is the ministry, uh, which is responsible for environmental governance. Then we have discussed about CPCB. Then third comes SPCB, which works at the state level and it is accountable to the state government. So it helps in raising public awareness. It coordinates with CPCB. It helps in curbing pollution and controlling it by monitoring and regulating pollution from various sources effectively. And it helps in enforcement of standards which are laid down by CPCBs, right? So these are the three main important bodies that are responsible for environmental governance in India. Now let us look at Pollution Control Board annual reporting. They prepare their annual report, they submit it to the central government and state government, and then that report is laid before both the houses of parliament within 4 months of the last date of the previous financial year. That time is about to come. Now it's June, so April, May, June, July. So they have to present it by July. Then their accounts and audited, of course, the audited report is also to be submitted to state government, which is further laid before both the houses of the parliament. And who is responsible for conducting audit? Any person who is eligible to be, who is qualified to act as an auditor under section 141 of the Companies Act 2013 can act as the auditor of these PCBs. But since these pollution control board are government organizations, so, and we know that all the audit of government organization is to be carried out by auditors who are empaneled with CNAG. So who conducts the audit? Of course, so indirectly CAG conducts the audit of PCBs. Then looking at some of the important provisions of different acts, first we'll see this important and prominent act, which is like the Companies Act for Environmental Compliance, and it is the umbrella legislation. Why I'm calling it umbrella legislation? Because it gives a lot of power to central government and inspectors, and it is from this act only that many provisions have been drawn and taken in other acts as well. So first, let us looking at the very powerful section of this act, section 3. It empowers the central government to plan and execute a nationwide program for the prevention, control, and abatement of environmental pollution. You must have heard about Swachh Bharat Andolan. Everyone of us know about this campaign. So ये campaign की power government के पास कहाँ से आई है? That is given to the government by this section. Government also has the power to lay down standards for quality of environment, to lay down the standards for emission or discharge of environmental pollutants. How much pollutant can an industry cause into the environment? So that standard is laid down by the central government by the virtue of section 3. And the same section empowers the central government to restrict any area. We have discussed about Taj Trapezium, that government ordered the industry to relocate from the area which is coming under Taj Trapezium. So that power is derived by the government from this Section 3 of Environmental Protection Act 1986. Then this act talks about the regulation of hazardous substances, emission standards, which we have already seen in Section 3, then how to prevent those hazards and how to protect the environment. Besides this, we have another important section of this act, which is Section 5. It empowers central government to direct the closure or prohibition or regulation of any industry operation or process. Means the government has the power to ask any industry to shut down, or even it can prohibit any industry to operate for any in any n period, n number of years. And it has the power to regulate any industry. It also has the power to direct the stoppage or regulation of supply of electricity or water, any other service to that premises. And if any industry is aggrieved by any such order, then what rescue do they have? Where to go? They can go to NGT, National Green Tribunal, which we'll discuss later in today's session. Then there are other few provisions, important provisions of Environment Protection Act. First is restriction or thresholds. So what restriction or thresholds we are talking about? Thresholds of emission of pollutants into the environment. So government definitely have the power to frame that threshold for different industries. And then Section 10 talks about the power and entry of inspection. So inspector has the power to enter and inspect your premises if he is doubtful that you are causing damage to the environment. So he can enter, of course, during the business hours. And he also has the power to take samples, to collect samples of air, water, or any other raw material from your premises, provided that that sample should be in a sealed container, and that sample should reach the environmental laboratories for further analysis within no time or at the earliest time possible. Then there is a concept of government analyst. Government analysts, they are the professionals who are working in environment laboratories, and they are going to analyze those samples which are collected from the premises, and then they'll analyze it and then they'll issue the report. That report is going to act as legal evidence. So these are some of the important provisions of Environment Protection Act 1986. And on the same premise, we have the provisions contained in Air Prevention Control of Pollution Act 1981. So if you read Environmental Protection Act thoroughly, then Air Act and Water Act, you just understand that you have already read, because they are completely on the lines of Environmental Protection Act. But Air Act just focuses on air and Water Act focuses on water. So power to take again in this act also, the inspector has the power to take samples of air and emission. And then they talk about the report or results of analysis or samples. There we had environment laboratories, and here we have state air laboratory. The only difference between Environmental Protection Act, Environmental Protection Act is the central act, and Air Act and Water Act, they are the state specific acts. There we had environment analyst, here we have board analyst. And if any person is aggrieved by any order passed under Air Act, then he can go to the appellate authority, which consists of one chairman and other 3 members, who may be judicial or technical. And if they are further aggrieved by the order of appellate authority, they can go and reach out to NGT under Section 31B, right? So these were some of the provisions of Air Act, which were very similar to Environmental Protection Act. Then looking at Water Prevention and Control of Pollution Act 1974. So CPCBs and SPCBs previously discussed that they are set up under Section 6 of Water Prevention and Control of Pollution Act 1974. This act talks about monitoring of water quality and regulation of effluent discharge. Moreover, there are heavy penalties that are contained into this act. Moving ahead to our next act, which is Forest Conservation Act 1980. So this act talks about the threat that can cause deforestation, and if any activity is to be carried out in forest, then you have to seek the approval of central government, and then it also categorizes forest into different categories. So it is basically centered around deforestation and stopping it or mitigating it and promoting afforestation. Then we have Biological Diversity Act 2002. It aims to conserve biological diversity, promote sustainable use of its components, and ensure fair and equitable sharing of benefits. Right? And what are biological resources? If we have to understand it, biological resources are all those resources. It may include plants, also animals, also microorganisms, also that have actual or potential value for humans. It may include your agricultural crops, livestock forest, any medicinal plants, marine organisms, fisheries, etc. So biological diversity talks about biological resources and its optimum utilization and equitable distribution, right? Then we have another act, Public Liability Insurance Act 1991. This act talks about those situations like if you are handling any hazardous substance and if you are exposed to any sort of accident, then you should be given proper compensation. So Public Liability Insurance Act provides for public liability insurance for the purpose of providing immediate relief to the person which is affected by accident occurred during while handling any hazardous substances. So these are some of the acts then under environmental laws, and we have one more act which is NGT 2010. We'll also discuss about it. Then there are certain principles of environmental laws. First is sustainable development. We have all read it since our childhood that sustainable development is the development in such a way that the use of natural resources in such a way that they do not compromise the need of future generation, right? Then precautionary principle, there is one important principle, precautionary principle. It says that whenever any activity raises threats of harm to the environment or human health, we should aim to prevent irreversible damage or any long-term risk. So we should take necessary steps to prevent any such activity that has the potential to damage the environment. That is what precautionary principle suggests. Then we have polluter pays. Polluter pays, as the name suggests, that any person who is doing wrong to the environment, he must bear the cost of restoration and damages. It should not be the case that government is taking the authority and it is replacing the old model of public funded cleanups. It is instead saying that whosoever is responsible for the pollution, he must bear the cost of that restoration and damages. Then we have intergenerational equity. So these are the core principles of environmental laws. Now we talk about the National Green Tribunal, which is set up under in National Green Tribunal Act 2010. It is a tribunal which advocates expeditious disposal of all the cases that come under its ambit. Expeditious disposal means the disposal should be done within the period of 6 months. And it has presence in 5 zones: north, central, east, south, and west. In talking about north, that tribunal set up in Delhi, which is its principal bench. Talking about central, it is central bench is located in Bhopal. East, we talk about east. So east, the bench in east zone is located in Kolkata. Then, if we talk about South Zone, the South Zone bench is located in Chennai, and in West, it is located in Pune. So, it has 5 benches. The principal bench located at Delhi, and every bench consists of one chairman, chairperson, and 20 judicial members and 20 technical members. We must also understand that we understood that tribunal is set up with an intent to dispose the case within 6 months, maximum 6 months. But what cases can be referred to tribunal are all the environmental acts which we had discussed previously. They means can the order passed under those, all those acts can be challenged, can be referred to tribunal. It is not the case. They have specifically mentioned 7 acts. Orders passed under these acts can only be referred to tribunal, otherwise it would not be entertained by NGT. The Water Prevention Control of Pollution Act 1974, the Water Prevention Control of Pollution Cess Act 1977, Forest Conservation Act 1920, Air Act 1981, Environment Act 1986, Public Liability Insurance Act 1991, Biological Diversity Act 2002. So if any order is passed under any other act, so that would not be entertained by NGT. So you can understand that NGT is basically the environmental Supreme Court. And let me tell you that it is a gold mine for CAs. NGT can impose fines up to rupees 10 crores, plus if there is per violation, and plus if there is there is delay, so it can impose penalty of rupees 25,000 per day. And every fine which is imposed by NGT, it requires financial assessment. It requires financial assessment. It requires damage quantification, and it requires compliance auditing. So what 3 terms I'm using? Every fine needs financial assessment, it requires damage assessment, and the third is compliance auditing. All these terms, all these are the work and services of a chartered accountant, right? So NGT, since they dispose the case within 6 months, so there is a constant demand. And let me tell you that I know a CA in Chennai who specializes in NGT damage assessments, and he makes 15 to 20 lakhs annually just from looking after this tribunal work. And tribunal has 5 benches. It handles around 15,000 cases. You'll see the actual data, maybe the number would be more than 15,000. So it is on the lowest side. So it handles 15,000 cases annually. So each case has financial implications that somewhere requires the expertise. So it is definitely a field you should go for, because there is very less competition. The less CAs are there into this field, and it is definitely going to be a gold mine for chartered accountants. Then we have discussed about all Environmental Protection Act, Water Act, Air Act, Public Liability Insurance Act, Biological Diversity Act, and different environmental principles. We have discussed timeline of international events. Now is the time to look at the things from the lens of a chartered accountant. If you are setting up any factory, you need to obtain 2 types of clearances. And let me tell you, the industries have been classified into 4 categories, and that categorization has been given by CPCB, Control Pollution Control Board. So depending upon the industry, the type of industry, you need to obtain 2 types of consents, 2 types of clearances. First comes the consent to establish. This consent to establish is required to be obtained before starting a business, before starting any sort of construction of your business, or before setting up of any plant or machinery, right? So this clearance is must if you want to set up any industry, and it is must for red category and orange category industry. We'll discuss about that also. types of industry. So the very first clearance is consent to establish. Consent to establish is a consent which is a clearance which you need to obtain before setting up an industry. Here I've quoted the example that if you are planning to set up a paper manufacturing unit, so before starting any sort of construction, you need to obtain this consent to establish. And who is going to issue this consent to establish is your state pollution control board, right? So once you have obtained this consent to establish, you can go ahead with construction activity of your plant, of your premise. Then another type of clearance which you need to obtain is consent to operate. So consent to operate is to be obtained once you have set up your factory, but you are yet to begin your commercial production, commercial operations, right? So before starting with commercial operations, you need to obtain consent to operate. This is again going to be issued by SPCB's State Pollution Control Board. The continuing example that once the paper mill is constructed and all the effluent treatment plants and air filters are installed, the company must apply for CTO from UPPCB. Only after obtaining CTO can it start producing paper commercial. And this CTE and CTO both have the validity. CTE, that's consent to establish, it comes with the validity of 1 to 2 years, whereas consent to operate, CTO, comes with the validity of generally 5 to 10 years, depending on the type of industry you're talking about. And CTO needs to be renewed time to time. So here's the summary chart. CTE is required at pre-construction stage. CTO is required at post-setup, pre-operation stage. And why do we need it? To verify that proposed setup is environmentally sound, and CTO is required to permit actual operations after compliance verification. They are issued by SPCBs and they have the validity 1 to 2 years, and CTO has the validity 5 to 10 years, right? So suppose you choose the field of environmental auditing for yourself, then these are the papers you should be cautious of, and you definitely should look for while auditing for your client, right? CTO must be renewed periodically, and if you do not renew it, it can lead to penalties. Now, here I have attached the this CTO and CTE clearance certificate, which is issued by Tamil Nadu Pollution Control Board. And here is the this zoomed in image. So consent to establish validity period for red, orange, green category is as below. It is all EIA project. EIA means Environmental Impact Assessment project. So environmental impact assessment, it is a mandatory process in India under the EIA notification 2006. And it identifies and evaluates the potential environmental impact of a project before it is granted environmental clearance. And this EIA notification, which I'm mentioning, it categorizes the project into 2 categories: Category A project, Category B project, right? So consent, you can see that CTE is given for 7 years, and all non-EIA projects 5 years. And then consent to operate and renewal of consent validity period is as below: 5 years for red industry, 10 years for orange, green for 14 years, right? So these CTE and CTO validity, they differ from state to state. So it may happen that Tamil Nadu Pollution Control Board, it may have issued the CTE for 7 years, but maybe UPPCB, it may issue CTE clearance certificate just for 1 year or 2 years, right? So it varies state to state. Moving ahead, now let us talk about the type of categories of industry, which is suggested by CPCB, and you can find this category of industry on CPCB website itself. So first category is red category industry. Red category industry means all those industries that have the potential of causing high pollution and they require strict environmental monitoring. So if we are setting up any sort of red category industry, for example, thermal power plants, cement plants, sugar manufacturing, oil refineries, tannery units, slaughterhouses, so you would definitely mandatorily require CTE and CTO. Then we talk about orange category industry. So these industries have the potential to cause moderate pollution. They again need CTE and CTO. And so, how is it different from category and orange red category industry? The procedure is slightly liberal to obtain CTE and CTO. That is the only difference. Otherwise, here also you require CTE and CTO, but the compliances or the procedure may be liberal as compared to red category industry. And like bakery products, automobile servicing, cotton spinning mills, these type of industries come under orange category industry. Then we have third category of industry, which is termed as green category industry, and they have the potential of causing very low pollution. They may require CT and CTO, but the process is relaxed as we have discussed in orange category industry also. And examples like assembly of electrical gadgets, tea processing, mineralized water units, ice making plants, etc. The last category comes is white category industry, which causes negligible or no pollution. And any industry which is any factory which is running on any renewable source of energy like solar power generation, bamboo and cane products, handloom and khadi weaving, cutting and sewing garments, so means they have uh, they cannot cause any sort of pollution, so they are termed as white category industry. They need not to obtain any CTE or CTO clearances. They just need to intimate SPCB on sale declaration basis, and they can operate uh, on the basis of this intimation itself. So this is the summary how the industry is categorized: red, orange, green, white. And then pollution level: red industry cause high pollution level, orange industries cause moderate pollution level, green industry cause low, and white none or minimal. Then these are the approvals and these are the examples. Moving ahead to the very interesting segment of today's session, that what are the opportunities for chartered accountants in when we talk about environmental laws. So one opportunity we already discussed is NGT, representations at NGT. The others ones are sustainability reporting and assurance, very interesting field. Carbon credit accounting and trading. Then CS can go for environmental regulations and compliance advisory. Then there is a field of green finance and sustainable investment advisory. Then we have ESG and climate risk advisory. Then another field is taxation and incentive structuring for sustainable projects. And then last one is forensic audit, investigation of environmental fraud. So first, let us talk about environmental regulations and compliance advisory. If you are well versed with any sort of law, you can set up your practice into it, right? So environmental regulation and compliance advisory is like providing advisory services, consultancy services regarding environmental laws to your clients, and that is only possible if you are aware of no even the minute details of different environmental laws that are applicable to a particular industry. Then another emerging field and very important field is ESG and climate risk advisory. ESG ESG means what? E stands for environment, S stands for social, and G stands for governance. So ESG reporting suggests that companies' information should be disclosed in such a way, means companies' operations information should be categorized into three areas. First is environmental. Environmental means it includes the information that what impact an organization have on air, water, land, biodiversity, how much carbon it is emitting, what's the energy efficiency level of a company, climate change mitigation, etc. Then comes the next category. It is S, social. Social means information about labor practices, human rights, community engagement, companies' relationship, diversity, employee health, and safety. And then comes the third category, which is known as governance. G stands for governance. It talks about companies' leadership and ethics. It includes information of board diversity, executive compensation, internal control company is implementing, any anti-corruption policies which the company is implementing. So the complete information of the company is to be divided into three segments: E, S, and G. That is what ESG reporting is. Now, if we talk globally, so there are many frameworks that support ESG reporting. For example, we have Global Reporting Initiative, we have Sustainability Accounting Standards Board, we have Task Force on Climate Related Financial Disclosure, we have Integrated Reporting Framework, we have CTP, uh, Carbon Disclosure Portal, then we have UN Sustainable Development Goals, then we have ISO 26000, European Union Non-Financial Reporting Directive, Global Impact Investing Network, and Climate Disclosure Standards Board. So these are the frameworks which are developed by different nations. And if I have to tell you uh, about the situation of ESG reporting in India, then there are many companies, many listed companies that are opting for voluntary disclosures as per GRI, as per SASB, as per CDP, as per UN Sustainable Development Goals. So they're voluntary choosing such disclosures. In addition, if we talk about India, there is a concept of BRSR, right? So it has been made mandatory by SEBI for top 1000 listed companies. Otherwise, if we talk about leaving BRSR aside, no other sort of ESG framework has been made mandatory on any company other than those 1000 top listed companies, right? So Global Reporting Initiative, it is adopted worldwide by many countries, many companies. It's an independent international organization that helps businesses, governments, and other organizations understand and communicate their impacts on issues such as climate change, human rights, governance, and social well-being. And it suggests that the information, the disclosure shall be divided into three parts: universal, sector, and topic standards. Um, it provides guidance like universal information, that information that is applicable to all the organization. Then we have sector specific information that information is applicable to industries such as oil and gas, agriculture, textiles, financial services. Then we have topic standards. It covers specific ESG areas, right? Just let me show you this GRI initiative. Just a moment. Well, okay, moving ahead, I'll show you later on. So for the time being, you can just have this understanding that ESG framework uh, has been implemented by different organizations, different countries in their own ways. So we have different standards. Now, talking about India, so ESG reporting evolution in India. So SEBI mandates BRSR, that stands BRSR means business responsibility and sustainability reporting. It has been made mandatory for from financial year 22 to 23 onwards, and it is aligned with 9 principles of national guidelines on responsible business conduct, NGRPC. Uh, So if we talk about BRSR reporting, it has to be prepared in XBRL format, and ESG reporting is divided into two parts: BRSR core and BRSR comprehensive. So BRSR core includes mandatory information, quantitative information, and focused information, and BRSR comprehensive includes 3 types of information: voluntary, qualitative, and narrative based. So this is where Indian CAs can literally go global. The BRSR is not just an Indian requirement, it is designed to align with global standards. And key disclosure as per BRSR is it includes general information, environmental, social, and governance. So environmental like energy use, water consumption, waste management, GHG emissions. GHG means greenhouse gas emissions. Social, gender ratio, community outreach, employee welfare. And then we have governance, board practices, ethics, and grievance mechanisms. Let me show you the BRSR report of Reliance. Mm. So this is the BRSR report of Reliance. And as we have seen that BRSR includes key disclosure, which includes general information about company details, CSR policy. Then other segment should include environmental information, social information, and governance information. So you can see the similar disclosures in the report, which is published by Reliance. So we have general disclosures. General disclosures include general information about the company like CON, name of the listed company, year of incorporation, registered office address. And this is the same format which you'll find on the website of SEBI. Let me show it to you. So this is the format which is available on SEBI's website. It is business responsibility and sustainability reporting format. Section A includes general disclosures, details of listed company, then products and services, details of business activities, product and services sold by entity, operations, number of locations where plants or operations offices of the entity are situated, markets served by the entity, then contribution of exports, it contains the details of employees, and also includes differently abled employees and workers. So this information comes under which segment? Social segment, like employees and differently abled employees, participation, representation of women. So this comes under S, social. And going above, differently abled workers, turnover rate for permanent employees and workers, then holding subsidiary and associate companies. Then we have CSR details, transparency and disclosure compliances, overview of entities, material responsible business conduct issues. So you see, it's a 35-page format, which is to be provided by 1,000 listed companies. Then we have section B, management and process disclosures. Then section C, principle-wise performance disclosure. So this is the standard format, which is to be adopted by all the companies. Now let us look at Reliance report. It includes section A, general disclosure. Then in the same format, it includes the information of product, services, operations, then the details of employees, holding subsidiary associate companies, and then CSR details. So the same format which we have seen on SEBI's website, in the similar format, Reliance has published its BRSR report. Then section A, general disclosure. This materials contains the information of material issue identified, rationale for identifying the risk opportunity. So these all are coming under the section A. Then section B was about management and process disclosure, as you can see in this BRSR. Management and process disclosure. So the same information is contained here. Same questions. Whether your entity's policies cover each principle and has its core elements of the NGRBCs. So you can find same information in the same format on all the companies which comes under 1000 listed companies list. So that was what I wanted to show. Yeah. So moving ahead, we have already seen it, BRSR framework. Then this was the screenshot I attached to help you how to navigate to this SEBI page and this PDF for format of BRSR on SEBI's website. So this we have already seen. Now, just a piece of information. So far, we have been discussing about BRSR. So, do you know that BRSR is not India's first foray into ESG regulatory frameworks and disclosures? Like, I've been continuously saying that BRSR has been implemented from financial year 22 to 23 onwards. But let me tell you that prior to BRSR, there was business responsibility reporting guidelines which were framed by MCA long back in 2009. So BRR served as a platform upon which a ESG reporting framework having much broader scope could be developed and served as the launchpad for BRSR, and it took a decade to refine and broaden its horizon to meet the complex ESG disclosure requirements, right? And how BRR and VRS are different. So here in BRR, we had 5 reporting sections. In BRSR, we had 3 reporting sections: general disclosure, management and processes, principle wise performance. In BRR, we had universal or single format. In BRSR, we are having in essential indicators and leadership indicators. In BRR, we had 59 questions, and in BRSR, there are 140 questions. And 98 are mandatory and 42 are based on leadership. BRR, mostly it was qualitative. BRSR includes qualitative as well as quantitative data. BRR was to be reported annually, and BRSR is to be reported annually, plus it is to be reported on MC21 portal. Right. So you can see that this is not something which a government, which SEBI thought in these recent years, but this concept has been there in their mind for last 15 years. Right? So this was the screenshot of Reliance, which we Reliance BRSR report, which already seen. Now, these are the comparison of ESG frameworks. GRI stands for Global Reporting Initiative. It is it focuses on stakeholder impact and sustainability. It is widely used globally. In India, it is being adopted voluntarily. SASB, it talks about, it lays a standard about financial materiality, right? Then TCFD task force on climate-related financial disclosure. Then we have CDP, Carbon Disclosure Project, IR integrated reporting. So this is the same information which we have seen in the timeline chart. Then it contains additional information. GRI was started in 1997. It is based in Amsterdam, Netherlands. CDP emerged in year 2000. It was based in London, United Kingdom. Then I integrated reporting framework, again, London-based ESG framework, and SASB is now merged into Value Reporting Foundation, and which is known to be IFRS, right? IFRS Foundation. So SASB, ISSB, they both are now the part of IFRS Foundation, and we have international standards, IFRS, on this ESG framework. So here's the chart, which ESG framework is applicable to Indian companies. So nothing is mandatory in India as of now, but yes, GRI, SASB, TCFD, CDP, IR, they are widely used by companies. So this was all about BRSR. Now moving to our next concept, which we all are aware of, CSR, Corporate Social Responsibility. Details are contained in Section 135 of the Companies Act 2013. So as a chartered accountant, you can assist in, you can either present before NGT. Second option we have is BRSR reporting, and also reporting as per different frameworks, because there are chartered accountants who are engaged in BSR reporting, and since BRSR reporting is on the lines of global standards, so if you are if you understand BRSR, you will definitely able to understand other global frameworks as well. So you can assist in those in preparation of your company's financial statements or any company's financial statement as per those frameworks. And there are chartered accountants who are making huge money by just engaging in this BRSR reporting and other global financial frameworks, global framework, ESG frameworks reporting, right? Now, the third field is CSR, corporate social responsibility. You can provide advisory related to CSR to your companies. CSR, we all are aware, it stands for corporate social responsibilities. And every company who is having net worth of 500 crore or more, or turnover of 1,000 crore or more, or net profit of 5 crore or more, during the immediately preceding financial year, shall constitute CSR and should spend at least 2% of the average net profits of the immediately preceding 3 financial years. And then what forms the part of CSR is if you are spending your money in eradicating hunger, promoting education, gender equality, environmental sustainability, ecological balance, then of course that expenditure would qualify for CSR, right? Then another opportunities for chartered accountants is carbon accounting. So carbon accounting is literally creating a new currency. If you see, CAs are the, here is the fact sheet that India emits 4.7 billion tons of CO2 annually. And at the current carbon price of rupees 85 per ton, we are looking at a potential of 4 trillion market. And here, what gets interesting for CAs, companies pay 5 to 50 per ton just for calculating and verifying these emissions, right? And there are 3 types of emission: scope 1 emission, scope 2 emission, scope 3 emissions. Scope 3 emissions are the real gold mine because they're the most complex to calculate. And there is one firm, CA firm in Bengaluru, who is making just rupees 2 crores annually just by calculating this is scope 3 emissions for tech companies. So GHG, greenhouse gas protocol, is like the accounting standard for carbon. You just need to master it and you are set for your life. So carbon accounting is definitely a very good field you can opt for. Then we have another segment, carbon trading and carbon credit trading scheme 2025. It's a market-based mechanism to reduce greenhouse gas emissions. And companies will definitely need CAs to calculate, verify, and trade carbon credit. It's like creating a whole new currency, and CAs are the bankers, right? So this is the timeline of carbon trading and carbon credit, CCTS 2025. In 2010, PET scheme was launched by Bureau of Energy Efficiency, and in 2021, Indian Energy Exchange launched a voluntary carbon credit trading market. So there is not any concrete regulator for carbon trading right now in India. There is just a voluntary carbon credit trading market, which is known to be Indian Energy Exchange. And Energy Conservation Act 2022 empowered the central government to develop a carbon credit trading scheme. And in 2023, draft blueprint released by MOEFCC and BEE for CCTS. And what are all the institutions that are involved in this carbon credit and CCTS 2025? It is Bureau of Energy Efficiency, Ministry of Environment, Forest and Climate Change. Then we have Central Electricity Regulatory Commission, which is known as CRC, and IEX. Definitely very emerging fields for chartered accountants. We can help companies, in getting carbon credits and carbon credits, in selling carbon credits, purchasing carbon credits, very important. So here are the key portals for carbon trading in India: Bureau of Energy Efficiency, MOEFC, which I already mentioned, IEX, it's a voluntary carbon trading credit trading platform, and then we have CERC, and POSOCO coordinates energy credits and trading, at including future integration of carbon markets. Here is the screenshot of this Bureau of Energy Efficiency. You'll go to its website, under the programs tab, you'll find this carbon market, and here from here you can get all sort of information, all sort of advisory which is issued by BEE and Indian Energy Exchange. So this information is accessible and available over there. Then we have the next area which can prove very beneficial for chartered accountants is green finance explosion. It is creating opportunities that didn't even exist 2 years ago. India's first sovereign green bond of rupees 80 billion was oversubscribed by 2.5 times. And that's how hungry investors are for verified green investments. And one more catch is here, that SEBI has mandated third party verification for all sorts of green bonds. And every single green bond needs a CA to verify that money is actually being used for green project. And for every single verification, you can charge as high as 1 to 2 lakhs per verification. So this is another very luring field for chartered accountants. And not only this, we do not just have ESG bonds or green bonds. We are going to have blue bonds in future. They are for water projects, and they are the next market overtaker. And the amount is estimated to be 50,000 crores over the next 5 years. Then we have transition bonds, and then sustainability linked loans. They have the interest rate tied to ESG performance. So you just imagine being a CA who certifies whether company deserves a lower interest rate or not. So we have a very good scope. We as chartered accountants have the scope in verification and of whether the company complies, or a company, how much companies complying towards ESG performance. Then we have green credit monetization. Then the last field for chartered accountants is environmental auditing. So it's environmental auditing. Just you have to tell that whether company has adhered to the environmental healthy environmental practices or not. So it's essentially an environmental management tool, and environmental auditor will study an organizational environmental effects in a systematic and documented manner, and will produce an environmental audit report. Just a moment. So, and who conducts environmental audit in India? For government organization, as we already discussed, that environmental audit is conducted by C&AG, and the C&AG has its own division, which is known as Supreme Audit Institution. So that conducts environmental audit for government organization. For private organization, any auditor can do environmental audit in India, right? Moving ahead, this besides environmental audit, we have another field which is known as environmental impact assessment. So environmental auditing is similar to post-mortem. Once the financial year is over, then you are analyzing whether the company had adhered to this policy or not. But environmental impact assessment, it is a futuristic tool. Means it assesses the impact on environment well in advance. So environmental impact assessment is an anticipatory tool. It takes place before an action is carried out, and it attempts to predict the impact on environment of a future action, and to provide this information to those who make the decision on whether the project should be authorized. And it is also legally mandated tool for many projects in most countries. So in both the areas, chartered accountants have definitely a lot of opportunities, be it environmental auditing or be it environmental impact assessment. But to be very frank, environmental impact assessment is gaining very much traction these days. So this is more interesting and more revenue generating field for chartered accountants. Then very important to know and understand the importance of digital environmental accounting. We see and we feel artificial intelligence everywhere. So if we are having the doubt that how we are going to fit into the role of environmental accounting, so then technology is there to help you out. Technology is revolutionizing environmental accounting faster than any other field. AI can now calculate scope 3 emissions, which we discussed in previous slides, that for carbon accounting, you need to disclose 3 types of scope emissions: scope 1 emission, scope 2 emission, and scope 3 emission. So scope 3 emission can now be calculated from thousands of suppliers in minutes, work that used to take months. So blockchain is being used to track carbon credits from creation to retirement, eliminating fraud. And there is a mind-blowing fact that satellite data can now detect deforestation in real time, and CAs need to incorporate this into their financial risk assessment. IoT sensors in factories, they provide real-time emission data, making monthly reports obsolete. So CAs who master these technologies, they are changing premium. They know they are changing the whole scenario, and they are charging the premium rates. And there is a one CA in Pune who is using machine learning, and he is predicting climate risk for insurance companies. He is charging around 3 to 5 lakhs per assessment. So you can see how much revenue generating this field is. And if you are using this artificial intelligence, if you're using this machine learning in a proper way, then of course there is no end to the revenue you can generate for yourself. Then there are success stories of chartered accountants. Let me share some real success stories. There is a CA firm in Mumbai that started their ESG practice just in 2020 with one person. And today they are having the team of 15 members they are generating the revenue of 3.5 crores annually. And how? Just from the environmental services. And there is a individual CA in Bengaluru who is specialized in carbon accounting for IT companies. He serves 45 plus clients and he makes 85 lakhs annually. And not only this, there is another story that's more inspiring story. A CA who has become a green bond consultant. He certifies bond worth rupees 25 crores and works with investment banks in Singapore and London. So they are not exceptions, they are becoming the norm these days. Now, just uh, action plan for your next 6 months if you want to venture into this field. And it's a practical 6 month roadmap to environmental accounting success. So, the first starting 2 months, you can invest in building your foundation. You can master the environmental laws and NGT procedures, and then you can get verified in GHG protocol. This is going to cost you around 50,000, but it can generate 5 to 10 lakhs in the first year. Then in next 2 months, months 3 to 4, you can focus on advanced skill development, ESG assurance methodologies, and carbon accounting software. You can learn about them. And if you are well versed in the software skill, you can mint around 2 to 3 lakhs per project. And then last one, in last 2 months, fifth and sixth month, they are about market entry. You have to identify manufacturing companies, you have to identify real estate developers and listed companies as your target clients and start networking with your environmental lawyers. They are going to be your biggest referral source for NGT cases. So this is how you can enter into this field. Then there comes a question that what to charge and how to scale. So this is for BSR preparation, you can charge. For BSR preparation, you can charge 2 to 8 lakhs per company. For carbon footprint assessment, there you can easily charge 1 to 5 lakhs per study. For ESG assurance, you can charge 3 to 12 lakhs per engagement. For green bond verification, which we discussed, everything which has already been discussed in previous slides, so you can charge 2.2 to 5 lakhs per project. And if you are serving as NGT expert witness, you can charge around 25,000 to 1 lakh per appearance. And this is what to charge and how to scale. So you can categorize your clients into small clients, mid-sized companies, and large corporates. This is the practice we generally do in a traditional work. Also, we charge according to our clients. Now, the last step from my side is you should avoid common mistakes if you are heading into this journey. You should not. There are some technical pitfalls that should be avoided. Many CAs confuse carbon credits with carbon offsets. They are completely different instruments with different accounting treatments. So carbon credits and carbon offsets, they are different. You need not to mix, and you should be very careful. You should not mix scope 2 and scope 3 calculations. You should not ignore materiality in ESG reporting. So these are the things you need to be cautious of. These are the points you need to be cautious of. And then business wise, the biggest mistake is undercharging due to initial enthusiasm. So there are CAs who undercharge, they charge 50,000 for work, which is worth rupees 5 lakhs. So don't take on complex multinational carbon calculations without proper training. And if we talk about legally, NGT has strict deadlines, and if you are going to miss them, you are going to face contempt charges. So always maintain detailed documentation for assurance work. Professional indemnity insurers are getting strict about environmental claims. Uh, okay, we have a question, carbon credit and carbon offsetting. So carbon credit, what does carbon credit mean? Carbon credit is a permit that allows a company or a country to emit 1 ton of CO2. And it is usually the part of regulatory or compliance market. Whereas if we talk about carbon offsetting, it's a voluntary action, uh, carbon offsetting, where individuals or companies they invest in environmental projects to compensate for their emissions. Like common offsetting projects, they include afforestation, reforestation, investing in renewable energy, methane capture, uh, energy efficient machinery. So this is what carbon offsetting is. Like you are making good for any damage you have done, right? For any extra emission you have done in the environment. And carbon credit, like you are purchasing, uh, it's a permit. It's a sort of permit that allows a company to emit 1 ton of CO2. So that what uh, carbon credit and carbon offsets mean. Then this is the last slide of today's session. How you can build your environmental CA practice. So building a successful environmental CA practice, it requires strategic thinking. And for team building, I would suggest you to hire junior CAs who are passionate about environment, and they are easier to train and they are very enthusiastic. You can partner with environmental engineers for technical expertise in law firms for NGT work, NGO relationships, and for marketing, rebrand yourself as green CA, not traditional accountant. Speak at environmental conferences, not just CA conferences. And there are CAs who have built their entire practice through LinkedIn, thought leadership on environmental topics. Like, and technology wise, invest in carbon calculation software like SEMA Pro or Gabi. ESG data management platforms are essential for large clients. Right. So this is how you can set up your CA practice. So that was all from my side, and there might be some questions. Let me.
Most of the questions you answered in the webinar itself.
Okay, okay. Okay,
Yeah.
okay, Aman. Uh, just. Hmm. So there was a question which I received. Just one question only. What are the essential software? So as I've already mentioned in the slide itself, that you can, if you are going for carbon calculation, so you can go for SEMA Pro or Gabi. And if you are just starting, means if you're starting other than your carbon, this carbon accounting, you can, your Excel is enough for basic work, and uh, that would be sufficient for you. Okay, so otherwise for carbon credit, you can go for Gapi and SEMA Pro. Okay, so yeah, over to Aman.
Yes. So, any more question or shall we end?
You see if there are any questions. Wait, let me
I'm checking.
stop.
Yes, I covered every question in the webinar itself.
Okay, okay. Okay, so in case there are no questions, we can wind it up. So shall yeah,
1 second. In total, 371 participants joined today.
okay, okay.
So we are going to close the session now. I thank Gyati ma'am for amazing seminar on environmental laws for CAs on this Environment Day. And thank you, ma'am, for being our distinct speaker, for your sharing your expertise and thought-provoking things on this topic. I'd also like to acknowledge the efforts of Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI for conducting such an informative webinar. It has been a privilege for me to moderate this session and facilitate such a meaningful discussions. Thank you, everyone.
Thank you, Aman.
Hello. Yes, you can.
Thank you, everyone.
Thank you.